All right, so we're working through this. We're about halfway there. In this video, we'll eclipse the halfway mark. So far, we've gone through our first four bullet points. First is do very little, honor and celebrate and work through the funeral. 2 is don't claim any authority until such has been appointed. 3rd is don't pay anything out of your own funds, with that one caveat dealing with funerals. 4th is talk to an attorney, and that video goes into some of the things you'll want to consider in that process. Our next bullet point, and I will tell you, this is so much easier said than done. It almost pains me to even say it because it's going to be very frustrating for a person who ends up in charge of an estate or working through the small estate process. Number 5 is don't distribute anything. There is a very strict order of how assets are to be distributed. The reason the court wants to be involved in a probate process, and in Indiana, as it says in that video, if you go watch that video, $50,000 or more in a person's name after that person dies, the state really wants to make sure that the assets of that person are properly allocated in the right priority. And at the top of the list, well, at the very top of the list are secure creditors. Right behind that are administrative fees, which might include filing for probate, hiring an attorney and paying the attorney, personal representatives. It could mean administrating and maintaining property within the estate so it's safe, paying for insurance, making sure taxes are paid. If we've got a house, making sure the utilities are kept up. So those are very high priorities. Funeral expenses, reasonable funeral expenses, are right behind that. And then there is the state and the federal government that wants to put their priority stamp in there. They want to get paid, and then we have unsecured creditors, and that could mean credit cards, uncollateralized loans, a variety of different things that might be out there that need to get in there. And I will tell you, that's where it gets rigorous, and that's where those people will try to move themselves to the front because they know they're not a priority. And it goes back to the first video in, don't claim authority and certainly don't pay out of order because you call the credit card out of courtesy to say this person's passed and to freeze the account. They'll tell you what they need from a logistics standpoint, a copy of the death certificate and some other information. But there have been instances where I've had credit card companies say, you know what, while I got you on the phone, why don't you just go ahead and pay this and then you can get paid back by the estate later. Well, the reality is we don't know if there's going to be money in the estate. I've seen estates with multiple properties, what looked on paper to be $500,000 worth of real estate, that because of mortgages, judgments, all sorts of other things and other debts that are out there tied to the properties, we actually ended up insolvent in the estate, and we ended up with families fighting over nothing. But if a creditor had been paid early in that process by somebody out of pocket, there's no money to pay that person back. And that's not something that I can say, hey, I paid the credit card company, I want paid back now. You go stand in line with the other creditors at that point to be reimbursed. And I will tell you, in Indiana, the state of Indiana, by law, has made itself a known creditor to anyone who dies in Indiana after the age of 50 or 55 and older. And the reason they did that is because they want to be reimbursed for Medicaid or other agency expenses that they've laid out during that person's lifetime. Now, they can only start billing when the person turns 55. They assume that they've given everybody $1 or more. And so you have to let the state know if, in fact, a person's died. And they become, like I said, that right behind the funeral. And in fact, what the state has said is the funeral can only be $2,200 if you've received Medicaid or money from the state. It's about $2,200. It's actually a series of statutes you have to go through and figure out the math, and that's what it is. So there's $2,200 roughly that gets paid towards a funeral. Then the state gets in and gets paid. And if someone was in a nursing home for 4 or 5 years, that could be tens of thousands of dollars. So then they get paid. Then the funeral comes back in, or the federal government if you owe taxes. And then we get down to the next level. So the funeral comes in ahead of the creditors to get the balance paid. We may never get that way. We may never get past paying back the state. We may not even have enough money to pay back the state. We may not owe the state anything, but we don't know until we go through the process. We invite them to submit their claim, and we wait to see what their bill is. Now, I will say the state of Indiana has gotten much more aggressive in the last 18 months or so to making sure that they're taken care of in the right way at the right time. So if someone were to pay money out to an inappropriate person, you pay $8,000 to a funeral when only there was a chunk of that should have been paid before Medicaid was paid, there's a liability that someone's going to have to answer to. So that's why we want to not distribute or pay out before it's time. Now, that seems pretty straightforward. The bigger issue that we have is this next step, self-distribution, if you will. When people have a house and there's things in the house, it's amazing how many of those things start to wander off, can't be found when somebody goes to do an inventory. The person, if we are in a probate circumstance, a person appointed by the court, we'll call them a personal representative. That's the generic term for executor if there's a will, administrator if there's not. But PR, personal representative, is the person the court appoints to take care of the estate. The personal representative, once appointed, is responsible for doing an inventory of all the assets of the estate so we can get a value on the estate. That way we can say, well, here's what the value of the estate is: houses, vehicles, personal property, bank accounts, all the different things that might go into the estate. That is then available to, in some cases, the court wants that filed. In some cases, beneficiaries or heirs can ask for that inventory to know what was in at the beginning. And then as we go through the process of paying things and going through the process of probate, there'll be expenses that will be debited against that. Now, the stuff in and around the house. It's real easy for someone to walk through and say, oh, I loaned this to him, and so I want to make sure I take it back. He said I could have that, so I'm going to go ahead and take it. Maybe they don't say anything, they just take it. You hear stories about, well, they knew there was money in the house, and they dug around, they found it, they took it, and wasn't there when the PR went to look for it. That's not legal. It's really not legal for someone to do that, and it causes some consternation for the PR who has to gather the information about the inventory and then at some point pay bills in the proper order. So if now there was, I see this happen. Someone's like, well, the car's just sitting there not being used and this person needs a car, so they took it. That's not legal. That's not how it works. And if that car was wrecked, we probably don't have insurance on it. So now there's a liability issue there. So there's a lot of real simple things, it would seem, that can happen, but they shouldn't. This is what I was saying. This is not an easy thing to stay in control of because things just wander off. You may not even know by the time you go to do inventory that there was, I was in a client's house a few weeks ago, and they've got this gorgeous collection of ships, big model ships. And it's very, very valuable. But if I hadn't been in the house recently to know what's still there, what had already been given away or sold or something like that, and suddenly I walk in and everything is gone, I don't necessarily know what was there. So this is not easy, but it's important. And again, it's one of the reasons why I would prefer to have everybody have that initial conversation so they know this is what you need to know about distribution. Don't just take things. There's a plan. There's an order that has to be followed. So point number 6, don't let people spend money, take things, or use things. As the PR, you run the risk of being liable for something. As someone just taking things, that's actually conversion. That's actually against the law, and it could cause them a big issue. Again, somebody goes and borrows a car and gets in an accident that's not insured. That's going to be a problem for everybody involved, including the estate, the PR, and the person driving the vehicle. So as hard as it is, don't distribute, don't spend, use, or take until it's time.